Welcome again to the Melling Law YouTube channel, where we're continuing our series about transfers on death. Now, with life insurance, the whole point is that you can transfer those funds upon death to the people who you want to receive those funds. However, there are a few different options. Some companies actually have disability riders, so if you're diagnosed with some kind of long-term illness or permanent disability, you can actually receive some or all of your insurance proceeds before you've passed away. But that aside, most of these transfers are upon death, and so it's important to know what are your different options for transferring your life insurance to beneficiaries. This is important, especially I want you to think about this from the perspective of a single young person who has a child or multiple children. Oftentimes, if you know they've been divorced or separated from that child's parent, it's due to money or maybe substance abuse or some type of other reason that would be a good reason for not wanting this child's parent in charge of the life insurance proceeds. However, the default the default procedures for leaving life insurance to children would put that other parent in charge, that non-custodial parent. So this is a common concern I get from a lot of young single individuals and from life insurance agents is what do we do in the case where we have a young person, they have a child, and they are no longer with that child's other parent, and they do not want, under any circumstances, for that child's parent to manage the funds. There are a few different ways to leave money to children. The one is directly, so you leave it directly to a child. Now that child, if they're under 18, they can't actually receive those funds. So we need someone else to receive those funds and manage them on that child's behalf. And that will be the child's legal guardian and conservator, which will be the non-custodial parent unless there's some kind of termination of parental rights entirely. If that is not acceptable, then we go to the next level, which would be some kind of, you're going to leave it to a particular person as conservator for that child. So that particular person, you get to choose, regardless of who the guardian or conservator may be, over these funds, you choose the custodian of those funds for that child, and they manage them for the child's benefit until the child turns 18. Once they turn 18, they get anything that's left. Another one, kind of the next level beyond that, is a UTMA designation. It's a little antiquated. It's not used as often as it used to be, but UTMA is just Uniform Transfers to Minors Act, and every state has a different one, but in Utah what that means is that it's the same as this custodian arrangement, but instead of vesting to the child at age of 18, it's 21. So you just get a few more years of oversight there before the child's old enough to manage their funds on their own. Finally, best practice is some kind of trust arrangement. If there's any chance that there are going to be funds left over when the child turns 18 or 21, then we want some kind of trust arrangement. Maybe that's an irrevocable life insurance trust, maybe that's a living trust, maybe that's a testamentary trust within the will, and then we're making the estate the beneficiary. That's very rare for other reasons, but we handle that on a case-by-case basis. But whatever that may be, there is some kind of trust that is managing the life insurance proceeds on behalf of this child. And the trust is governed by a trustee, and then there are procedures in place to put a new trustee in if the existing trustee, if anything happens to them. But you can put a lot more restrictions and protections on those funds. For example, if the child is permanently disabled and is going to be receiving benefits for that disability, you are able to withhold all of those funds and supplement those benefits rather than just replacing those benefits and having them lose some of their medical coverage. You can have those funds withheld until a much later age than 21. For some people, they might want that to be 25, maybe they want it to be 30, or even later for larger policies. Maybe you can put restrictions on there or incentives where they can receive their funds earlier if they finish college or a technical school. whatever that may be, these transfers of life insurance to younger persons, they are a little more complex than they might be on the surface. And then finally, transfers on death of life insurance to other people, following the same rules, except even if we're not dealing with minors, do we want these other people to receive the funds directly, or do we want a trust to manage those funds on their behalf for a while? Do we want to protect them if they become disabled, or if they have a bad business debt or a bankruptcy? Do we want to keep those funds back in a way that they're there as more of a safety net? Are we replacing a cost of living for the beneficiary? So think hard about who is receiving your life insurance funds, who do you want to benefit from them, and in what ways do you want to benefit from them? And work with your life insurance agent on these issues. If they don't know what to do to set it up and fulfill your wishes, talk to an estate planning attorney in your area to make sure that your life insurance is done properly to benefit those you love in the way that you want. Thanks for watching.